Oral arguments in the 11th Circuit in Atlanta on the morning of June 8th. The main issue, of course, is whether or not the individual mandate, the mandate that taxes you if you don't buy insurance, is constitutional, whether it's violative of the Commerce Clause, necessary and proper, and Tax Clause. We got a great decision from Judge Vinson in Pensacola. We actually got two great decisions from Judge Vinson in the district court. Last week was the oral argument in the Fourth Circuit concerning the Virginia. I believe there's also an appeal in the second. It is hoped that all three will then be consolidated for review by the U.S. Supreme Court next spring. We feel really good about this case in the 11th Circuit. The brief is fantastic. For any young lawyer who wants to know what an appellate brief should look like, how you intertwine the facts and the law, it is done very, very well. And we feel very good about the likelihood that the 11th Circuit will affirm Judge Vinson and find the act as a whole as unconstitutional. And of course, at that point, all of these circuit case decisions will go to the U.S. Supreme Court for final review. Paul Clement is the individual who's going to argue on behalf of the 26 states in the ObamaCare hearing on June 8th. He's a former Solicitor General for Bush 41. He is probably the most preeminent conservative appellate advocate we have in this country. And when we were able to get him to represent the 26 states, it was then a no-brainer that you give all the time to him and you let a genius handle that oral argument.